Welcome back. What we're about to witness is a guilty plea in real time, one of the most consequential moments in any criminal case. No jury, no dramatic trial, just a defendant, a judge, and a decision that will define the next several years of someone's life. Pay close attention to every question the judge is about to ask because each one has a very specific legal purpose.
Are we gonna count one on? Good morning, ma'am. Are you Destiny Vargas? And Mr. Rojas, will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Vargas, in cause number 26 DCCR 0081, the state has elected to proceed on count one only. It alleges that you committed the third-degree felony offense of harassment of a public servant from July 11th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you actually did what they charged you with?
Yes, Your Honor.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, it is.
Do you fully understand them?
I do.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Vargas is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of harassment of a public servant.
There it is. One word, guilty. But here's what most people don't realize: saying guilty in court isn't enough on its own. The judge still has to independently verify that this plea is knowing, voluntary, and factually supported. Think of it as a checklist the court must legally complete before accepting it. If any box doesn't get checked, the whole thing falls apart. Watch how methodically the judge works through it.
Sentence you in accordance with that agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas.
Okay.
All right, good luck to you, ma'am. You can go back to the bailiff. Quentin Sells, it's a competency, right?
Yes.
Quentin Sells.
Let's break down what just happened with Destiny Vargas. Third-degree felony harassment of a public servant. 5 years in the Texas Department of Corrections. She waived her right to appeal, surrendered her right to possess a firearm, and received credit for time already served. That entire process sentencing included took under 3 minutes. Plea deals move fast. Now we're pivoting to a completely different kind of case, and the contrast could not be more stark.
Let's see.
Good morning. Are you Quentin Sells?
Yeah.
And we've got cause numbers 25 DCCR 1473, 1474, and 1475. Mr. Sells is charged in each of those cases with assault on peace officer. I'm going to take judicial notice of the court's file in all 3 of those cases. Mr. Sells was previously found not competent to stand trial and was sent to the John Dunn Behavioral Science Center for competency restoration. I have received the report from them. In that, it includes a trial competency evaluation report dated May 4th of 2026. The opinion in that evaluation from a Dr. Emery is that Mr. Sells is currently not competent to stand trial. and that further treatment would be necessary for competency restoration. In addition to that, I also have the forensic psychiatry report, which is dated May 5th of 2026 also. It is from a Dr. Shahani, also has that same opinion that Mr. Sells is still not competent to stand trial. Then I also have a physician certificate of medical examination for mental illness. This is from Dr. Shahani, dated May 5th of 2026. It makes the finding as well that Mr. Sells is not competent. It does state that he does not meet the criteria for inpatient, but would meet the criteria for an outpatient commitment for competency restoration, that the nature of his mental illness is severe and persistent, and that without treatment, he would continue to decompose and or deteriorate and not achieve competency. I also have a physician certificate of medical examination from a Dr. Polizzato. This is dated, well, let's see, May 13th of 2026. It has the same finding that Mr. Sells is still not competent to stand trial, but that outpatient commitment is what he meets the criteria for, and that he would require further treatment for competency restoration. Is there any other evidence with regard to competency, Mr. Rojas?
No, Your Honor.
Mr. Coleman?
No, Judge.
So obviously, you both know, we all know that we do not have an outpatient competency restoration program here in Jefferson County. And so I will have no choice but to order further inpatient treatment at the appropriate facility. Hold on just a second. And so I am going to find at this time that Mr. Sells is still not competent to stand trial, that he is mentally ill, and that because of that, it is severe and persistent, and that if not treated, he would experience deterioration and the inability to function independently, and that treatment would be necessary. I'm going to order treatment at this point in an inpatient facility for a period of not to exceed 1 year under the civil commitment, and that we will await a report at that time. If something occurs before then where competency is restored, then they will let us know immediately.
Judge, I would like to say, I'm sorry to interrupt the court, but given the nature of these charges, the next time we are in court, if we are in a similar situation, the state will reconsider a way forward in these cases.
Okay, perfect. I know there's some civil locally, civil commitment that can be taken care of, but let's see if we can get maybe competency restoration between now and the next court date. If not, then we'll go forward that time. So you're going to go back to a hospital, follow all of their rules, okay, so that you can get better, take your medicine, and then we'll see if we can get your case taken care of.
I went to the health center and I went to all the competency.
Right.
With the mental competency with firearms.
Right. I think the doctors still think
Disagreements?
they think you need a little more treatment so that you understand all of your legal proceedings, okay? All right, you can go back with the bailiff. Mr. Rojas will visit with you. Thank you.
Let's pause here because this case raises one of the most important and often misunderstood concepts in the entire justice system: competency to stand trial. This is not about whether someone is guilty or innocent. It's not even about their mental state at the time of the alleged crime. Competency is solely about one question, right? Now today, does this person understand the charges against them, and can they assist in their own defense? Multiple doctors, Dr. Emery, Dr. Shahani, Dr. Poliato, have all said no, and because Jefferson County has no outpatient restoration program, the judge's hands are effectively tied, that sidebar at the end. That's the court quietly wrestling with what comes next if restoration never happens.
Yeah, I don't think there's any expectation of restoration. I think there's more of an issue of. So anyway, take a look at it.
Yes, Judge, I think there's another way we can go
Okay,
with this.
I agree.
Next time.
Johnny Segeda or Segeda?
I think it's a good.
Good morning. Are you Johnny Segeda Jr.?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
Here you go, y'all.
Mr. Sagita, in cause number 26, DCCR 0795, you're charged with the second-degree felony offense of burglary of a habitation from April 21st of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and
Yes,
voluntarily?
ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rowe?
Yes, ma'am.
Do you fully understand that?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 10 years in prison, which means you're leaving your punishment up to me. And as long as I don't give you more than 10 years, I can give you 10, I can give you less. It'll depend on the information that's brought to me at a sentencing hearing. But as long as I stay within that range, you are giving up your right to appeal. Do you understand? I want to make sure you understand you have an absolute right to have a jury come in and determine 2 things. The first is if you're guilty or not. And then if they find you guilty, you could leave your punishment up to them.
Yes, ma'am.
If we go forward this way, you're waiving that. Is that what you want to do?
Yes, ma'am.
Do you also understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Also, it looks like as part of that agreement, the state is agreeing to dismiss cause number 26 DCCR 0796. Is that your understanding? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Sagata is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing. And the probation department will do a pre-sentence report. That'll give me more information about your cases, and then we'll come back later for sentencing. Anything that you think is important for me to know, make sure you get that information to Mr. Rojas. He'll present it to me on your behalf when we come back. Okay, you can go back with the bailiff.
Now that was interesting. Johnny Sajeda JRB pleaded guilty to second-degree felony burglary of a habitation, but notice what didn't happen. He wasn't sentenced today. The judge accepted the guilty plea but reset the case for sentencing. Why? A pre-sentence investigation report, or PSI, needs to be completed first. That report will give the judge a full-picture criminal history, background, victim impact before she decides where within that 10-year cap to land. This is actually a significant protection for the defendant. More information means the judge can make a more informed and potentially more lenient decision.
What about Byron Morris? I have it. Let's do Byron.
Byron Morris.
Well, maybe some stuff. Hey. It's all right. Good morning, sir. Are you Byron Jamal Morris?
Yes, it will.
And Mr. Rojas, will your client waive the formal reading of the motion?
It will, Your Honor.
Mr. Morris, in cause number 15-21651, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation March 21st of 2016 for the second-degree felony offense of burglary of a habitation, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you committed the new offense of public intoxication November 6th of 2025. And is that true or not true?
Not true.
Count 2 alleges that you failed to report to the Jefferson County Probation Department for your administrative hearing December 18th of 2025. Is that true or not true?
Yes, ma'am. True. True.
Count 3 alleges that you failed to comply with the curfew and that you were outside of your approved residence at approximately 11:59 p.m. November 6th of 2025. And is that true or not true?
True.
Count 4 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you admitted to using alcohol on September 15th of 2025. Is that true or not true?
Not true.
Count 5 alleges that you're behind in your court-assessed fees as of January 14th, 2026 in the amount of $7,711. And is that true or not true?
True, Your Honor.
Did you enter your pleas of true to counts 2, 3, and 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a cap of 5 years in prison. Is that your understanding?
Yes, ma'am.
State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. Morris is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 2, 3, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation. I'm not going to do that today. I'm going to reset your case for sentencing so that the probation department can do an updated report. Also, so that the state can bring any witnesses with regard to counts 1 and 4. And I'm assuming if there's an officer, even with the public intoxication, it wouldn't be longer than a regular day. We can add it to the end. All right, so we'll set this so that we have time for a couple of witnesses just on a regular Tuesday docket. Anything that you think is important for me to know, make sure you get that to Mr. Rojas, and he'll present it to me on your behalf when you come back.
Yes, ma'am.
Okay, you go back with the bailiff.
Thank you, Your Honor. Thank you.
Thank you.
And that's a wrap on today's docket. 3 very different cases, 3 very different outcomes, a completed sentencing, a competency battle with no clear finish line, and 2 probation-related matters headed back to court for a final reckoning. What strikes you about how quickly these decisions move? Because for the people standing at that podium, every word the judge says will echo for years. If you want a deeper dive into any of these cases, plea deals, competency law, or probation revocations, drop a comment below. Court's adjourned.